people of unique languages and a band of rich cultures. Aboriginals of various groups were among the first to inhabit and settle in Canada, from east to west, north to south. Canada was a land of deep tradition and ingrained spirituality. However, the peace of the native people was interrupted by the arrival of the European settlers. After hundreds of years of mistreatment, assimilation, and cultural genocide, when the Constitution was brought to Canada, there was a glimmer of hope for the First Nation groups. After all, Aboriginals are the only minority group to have a designated section in the Constitution.
Section 33 details the rights and protections of Aboriginal groups. With the Charter and overall Constitution, the government makes an attempt at recognizing that the Aboriginal peoples of Canada are a distinct group with a set society, ingrained traditions, and a long-standing culture. The courts, as well as many First Nations people, recognize that these rights are inherent collective rights which flow from the original occupation of the land that is now Canada.
The Charter, specifically Section 25, details that the other rights of the document must not interfere with the Aboriginal rights given. This means that non-Aboriginal citizens cannot argue for an infringement of their, for example, Section 15, equality right due to a granted Aboriginal right. This is rightly so, in the sense of paying respect to the original inhabitants of Canada and recognizing their lifestyle. Land claims and treaties are also acknowledged in the Charter, which settles some of the tension between the government and native groups. In it, the Royal Proclamation of 1763 is upheld, such that all rights given through the document are maintained by the present government and entrenched. This is very significant to all First Nation groups because these treaties are the only things that publicly show obligation by the government to respect the native lifestyle. Section 25 and 35 protect a spectrum of rights. However, even in present day, it is very difficult for Aboriginals to practice the granted rights.
The Supreme Court argues that the native peoples should demonstrate that the right was integral to their distinctive indigenous societies and exercised at the time of first contact with the Europeans. Cases such as R.V. Marshall and R.V. Sparrow are examples where individuals had to prove the validity of their traditions and actions according to the practices of the past, which is extremely limiting. This burden of proof ignores that a society is able to adapt and fails to interpret treaties to modern-day practices. In regards to fishing, both cases argued their rights in reference to treaties, but the court dismissed the claims. In matters such as these, the Charter becomes extremely significant in protecting the lifestyle of the Indigenous people.